JBNN keep you informed. I'm Michelle Jones. Hi guys. Before we go into the news, please remember to like, subscribe, leave a comment, and to share the news with someone today. Now on to the news. DPP to rule whether charges be laid against cops accused in Ocheria's killing. The Director of Public Prosecutions will be asked to determine whether criminal charges should be laid against the 3 policemen arrested in connection with the fatal shooting of a man at a mother's fast food restaurant on Main Street in Ocherias, St. Anne over a week ago. The policemen, along with 5 civilians, are under investigations for the murder of 30-year-old Kajay Sims of Bartlestown, Gale, St. Mary. A senior investigator said that a file has been prepared for submission to the DPP. Sims was gunned down inside the popular fast food restaurant during a brawl with a group of men on January 27. It was reported that Sims and his friend got into a dispute with a group of men which became physical. It's alleged that he used a knife to slash 2 of the men. Investigators say one of the men went outside, returned with a gun, and shot Sims in the chest. The group of men then fled the scene in a convoy of 4 vehicles to St. James. Sims was taken to hospital where he was pronounced dead. Investigators arrested the policemen and the civilians after reviewing CCTV footage inside the restaurant. Nigerian among 3 detained in relation to Ganja bust in Westmoreland. 3 men, including a Nigerian national, are still being questioned in connection with a major Ganja bust in Westmoreland last week. The men were captured in a coordinated joint maritime operation conducted by the Jamaica Defence Force and the Jamaica Constabulary Force near Cave, Westmoreland on Friday. More than 400 pounds of marijuana was seized in the operation. The JDF Coast Guard had reported that its personnel intercepted a suspicious vessel during an operation targeting people involved in the illicit drug trade. 19 drums of fuel and the marijuana were found on the vessel. The 3 men, including the Nigerian, were held at a nearby premises. DPP and judge at odds after case withdrawn before a sentence that would shock public's conscience. There's a legal firestorm brewing over the direction of public prosecutions. DPP withdrawal of a case last month from a judge was about to sentence a man who pleaded guilty to rape and grievous sexual assault. DPP Paul Llewellyn has been chastised by the judge and criticized by several members of the legal profession for her action. They have emphasized that the DPP had the right to appeal rather than to stop the proceedings and to start afresh before another judge. It was reported that the judge was visibly upset, remarked that the DPP had also stopped a murder case some time ago in which the judge was to preside. But in response, Llewellyn said what she did last month in entering a nolle prosequi was done in the interest of justice because the non-custodial sentence that was being indicated was not the appropriate sentence given the gravity of the allegations. It cannot be that the pendulum of justice must only swing in one direction for the accused. It must also swing for the victim, Llewellyn stressed. She said the process in arriving at the sentence was irregular. Attorney at Law George Clue, president of the Southern Bar Association, when asked for a comment on the issue, said last week that he heard about the matter from some attorneys who were present in court on January 26. In my view, it is an abuse of discretion to use nolle prosequi in that manner because if the DPP is dissatisfied with the sentence imposed by the judge, she can appeal it, Clue asserted. He said the case would not have to go before another judge. If a sentence is too lenient or a judge imposes a sentence that he or she is not empowered in law to do, then the DPP can appeal, Clue added. On December 18 last year, when the social inquiry report was ready, the judge again indicated the sentence that was going to be given in accordance with the sentence indication, and it was reported that the judge then remarked that it was open to the Crown to appeal if it was aggrieved by the sentence. Llewellyn pointed out that the information from Senior Deputy Director of Public Prosecutions, Jeremy Taylor, KC, who first had conduct of the matter, was that when the matter was first discussed in October last year in respect of sentence indication, Taylor said he could not agree to a non-custodial sentence given the gravity of the allegations. We believe that such a sentence would shock the public's conscience, she added. The judge apparently did not seem to be in disagreement with what defense counsel was saying, Llewellyn said. One understands the urgency which all stakeholders share to dispose of matters. However, because we are dealing with real people who have been assaulted or victimized or killed, prosecutors have to explain to the victims or their relatives how come the judge is going outside of the sentencing range, she disclosed. Taylor, in outlining what took place, said the trial was going to start so the complainant was at court. He said he and another colleague had conduct of the prosecution. However, before the accused man was charged with rape and grievous sexual assault was pleaded in October last year, his counsel asked if he could approach the bench. He went there, and what I would describe as an informal sentence indication took place. I said informal because it did not conform to the practice direction, and it did not come to the strictures laid down in the case of the King and Adrian Brown, which would have been in chambers with a writer and normally to get a social inquiry report, and that was not done, Taylor said. This was done in the bar of the court. When the judge said in the bar of the court, I'm minded to give him a non-custodial sentence, the Crown said no, because on the facts of this case, the offences were egregious, and we could never agree to a non-custodial sentence. This is a case where the accused lured the girl by way of social media to where he lived, and without her consent, he held her down and raped her, and held her down so that his friend could rape her too. When we went back to counsel's bench, defense counsel asked for the accused to be pleaded, and he pled guilty, and a date was set for sentencing. On the date for sentencing, I was present, and I put forward sentencing submissions as to why in this case a non-custodial sentence must not be given. I even cited authorities to show that notwithstanding the age of the accused at the time of the offence, a non-custodial sentence was not appropriate, Taylor outlined. The matter was set for another date. On December 18, 2023, when the case came back before the court, Taylor said he was not there, but from reports from the prosecutors who were in court, the social inquiry report was ready, and the judge indicated to the prosecution and the defense counsel that she was going ahead with the original sentence. So when it came to his attention, he approached the DPP. We even consulted with the complainant before we consulted with the DPP for the nolle prosequi, and the complainant was shocked that the judge was minded to give a non-custodial sentence. The nolle prosequi was entered on January 26 for the matter to commence before another judge, Taylor said. It was reported that the accused at the time of the incident was 16 years old and the complainant was 17 years old. As officers of the court, we always pay great respect to the judiciary and the fairness required to due process for the accused. However, we are obliged to maintain an independent professional judgment from all stakeholders in the administration of justice while we balance all factors with the public interest, Llewellyn said. Man who was on wanted list denied bail. Nigel Bailey, the St. James man charged in connection with the December 10, 2023 shooting death of 42-year-old Kemar Henry, has been remanded until March 26 following the St. James Parish Court's rejection of his lawyer's bail application last Wednesday. Bailey, who is of a Bickersteth address in St. James, is charged with murder in relation to the death of Henry, otherwise called Brocky and the Diamonds, who was gunned down by a group of men in his native Anchovy community on December 10. During Wednesday's court hearing, Bailey's attorney, Maurice McCurdy, applied to Parish Judge Sasha Mary Ashley for a bail on the defendant's behalf, citing issues with how the prosecution's witness reportedly identified his client. It's almost as if she's convicting him already, without even telling the police that indeed, I saw him shooting X, Y, and Z, and she has not said that. I say that to say, the case of the Crown is tenuous at most, very, very tenuous, and I am confident that when the matter is called for trial, and I'll appear for Mr. Bailey, we'll test these things, said McCurdy. But in rejecting the bail application, Ashley noted that one mitigating factor against Bailey was that he was reportedly held in St. Catherine following Henry's murder. This is a matter that occurred in the afternoon, so lighting is not an issue, and the Crown is relying on circumstantial evidence to establish that you are responsible for the death of Mr. Henry. They are saying that the evidence comes from a credible source because it's someone who knows you, Ashley explained directly to Bailey. The Crown is also saying that though you would have resided in Bickersteth, St. James, you were found more than a month later in St. Catherine District, and this raises the real possibility that you are a flight risk. I have listened very carefully to your attorney, but at this time, this court deems you unsuitable for bail. You are remanded in custody, Ashley added. Subsequently, McCurdy voiced his intention to appeal the refusal of bail for Bailey and ask that the judgment be granted to him in writing to that end. The matter was then set for March 26 to allow time for the prosecution's case file to be completed. According to the allegations, on December 10, Henry was among a group of people in the Anchovy community when they were approached by men traveling in a Toyota Axia motor car. Bailey and his accomplices reportedly exited the vehicle and opened gunfire, hitting Henry in the head before making their escape. The police were summoned and Henry was transported to hospital where he was pronounced dead. Bailey was apprehended by the police during an operation in Kitson Town, St. Catherine on June 4 and was subsequently charged with Henry's murder. He was also charged in relation to the October 24 murder of 41-year-old chef Owen Morris of a Tank Road address in Cambridge, St. James. However, that matter was not before the court on Wednesday. Allegations relating to Morris's killing are that he was standing at a business establishment in Cambridge when a white Toyota Fielder motor car approached. Bailey and another man, armed with guns, alighted and opened fire at Morris, hitting him all over his body. The men escaped in the waiting motor car, and Morris was assisted to hospital, where he was pronounced dead. JBN, we keep you informed. Please remember to subscribe, like, share, leave us a comment, and click the notification bell to receive our daily news items.